Well, good morning. We can go ahead and get started. We were waiting a few minutes to allow other folks to join in. I appreciate everybody showing up today. This is an ongoing series of webinars that Lewis Thomason is doing. For those of you who know us, we typically have a construction seminar on an annual basis in each of our 3 offices across the state in Knoxville, Nashville, and in Memphis. And due to COVID last year, we decided to take it virtual to give people an opportunity to still participate, but to do so without the risk of contracting COVID or being around others who had it and avoiding that potential altogether. And it has been received very well. So what we have started doing this year, given the uncertainty, is having a series of additional webinars in lieu of an annual seminar this year. And hopefully in the years to come, and potentially even later this year, we'll be able to have an in-person meeting, if not a full seminar with those of you who are in attendance today. But today we're going to be talking about a number of different pieces of legislation that were advanced before the Tennessee General Assembly this year, as well as some topics from the surrounding states to Tennessee. A lot of clients for Lewis Thomason and a lot of the contractors and architects and engineers that will be participating in this seminar, either as it is going on live or in the recorded version, do a lot of business outside of the state of Tennessee. And so there's a couple of points that we want to make known in terms of legislative initiatives in other states that are going on as well. I would remind you, if you have any questions as this is ongoing, feel free to type those into the chat box, or feel free to come on video, raise your hand and let me know, and we can address those either while we're going on with the seminar or as the seminar is progressing. So for some reason we're at the end. It's always better to start at the very beginning. So we can jump right into it. Before we really get into individual pieces of legislation, however, it's worthwhile to talk a little bit about the legislative process here in Tennessee. Unlike the federal Congress, which House of Representatives, Senate, which meet on an ongoing basis throughout the year with some periodic breaks in between, the Tennessee legislative cycle is really, and the legislative session is really fairly short. The Tennessee legislature is not a full-time legislature. It is only a partial of the year. It begins in January of each year and goes through typically the end of April or early May. And with that compressed time frame, as you can imagine, there are a ton of bills that are filed, but with a limited period of time in which to meet. Not all of those bills are actually taken up by the session in that particular year. Each year there's a filing deadline for bills, so all bills have to be filed typically by the first week of February. And once those bills are filed, they can then be assigned into the various committees and subcommittees before the House and the Senate. Now, once it goes through the committee process, they do some general discussion, determine whether it's a bill they want to advance to a full House or Senate vote. Once it is passed by both the Senate and the House, it can then go to the governor for the signature. But there's a lot of different twists and turns that a piece of legislation will go through during its life cycle. Going back to the compressed legislative session, you can't hear everything in one particular time, nor is every bill intended to be heard. Sometimes it's a placeholder. There may be multiple bills addressing the same subject, so those can be amended and combined into larger legislation. Some of the legislation is not necessarily something that's ready to be addressed by the legislature. A lot of times there may be one bill that is great for one particular aspect of industry, but there's other potential stakeholders that may have different feelings about it. And so there's a number of different turns that can take. It can go through the end of a session when the session is adjourned. And then just because the session is adjourned doesn't mean that the legislature it's out of session, but it's not necessarily inactive. A lot of those bills can go to what's called a summer study, in which time various stakeholders are brought together with the House and Senate sponsors of the legislation to talk about ways they can improve, see if they can find any common ground, and see if there's a potential resolution to advance that bill during the next legislative session. In Tennessee, we have a 2-year legislative cycle, which means if you have a bill in the first year that is not passed by the House and the legislature and signed by the governor, it's automatically rolled into the second year of the cycle. You don't have to refile that bill. It keeps the same bill number in the House and the Senate. It's just a matter of, well, it didn't pass that first year. We didn't have time to get to it. There were additional stakeholders we needed input from, whatever the case may be. That bill continues on into the next session and still has life. If it's not passed by the second session, then it's technically dead and will have to be refiled in whatever the next 2-year legislative cycle is. And that happens quite often because every year you will have thousands of bills that are filed, and very few of those actually see a House vote. In typical years, it's going to be fewer than 100, particularly if it is a substantive change that is sought to be made or a new statute. So the question becomes, if you have an issue that needs to be addressed through a legislative amendment or a new statute, how do you actually go about doing that? You and I personally cannot file bills before the legislature, and so we need to identify a House sponsor and a Senate sponsor. You need one in each house to make sure it is going to advance. There's a fair amount of times an initial bill is going to be filed by either a senator or a representative in the House. They then have to go find somebody in the adjoining House or Senate to be able to actually get that moving forward. So you'll have a Senate sponsor and a House sponsor. Well, once you've got that, and it's great, you can have an individual bill. If it's an individual, something that is relatively simple, straightforward, and has a limited scope, it may be that you can go to your individual representative or senator that represents you in your district. But oftentimes, legislation is much more broad than that, and so it's dealing with a particular industry or at least a particular sector of one industry, and for things like employment. It's going to be very, very broad, and there's going to be a lot of stakeholders that have an interest in that. So how do you actually go about it? Well, the good part for those of us that are in the construction industry, there are plenty of trade organizations that are out there that represent the interests of their membership. These range not only based on profession, as between in the construction industry, contractors, surveyors, home builders, architects, engineers, and various companies, but also individual sects within those companies. Whether it be a potential class of contractor, if you're or a subcontractor, general contractor, there's organizations that represent both types of entities there, as well as if you're doing particular type of work, like the Tennessee Road Builders Association. The same holds true with designers, with the AIA and NSPE or TSPE, as well as ACEC on behalf of the companies themselves. Those organizations and their their executives do a fantastic job of protecting the rights and the interests of the membership for their particular organization within the construction industry. And those organizations work well together up to this point. As you may recall, last year, there was a tremendous effort that was undertaken by these organizations to pass substantial amendments to the statutes that apply to construction in Tennessee, with the lien laws, the Consumer Protection Act, the Prompt Pay Act, and the construction defect statutes. And we'll talk a little bit about those later if we have time, but the primary focus today is going to be on some of the initiatives that were before the legislature in 2021. So what do we typically see being the primary considerations of the construction industry? It's very broad. It can run the gamut of things. This year, there was a lot of work done in terms of designers with architects and engineers in terms of licensing, regulations, funding for projects, which is equally applicable to contractors. But for any project, you got to have a design before you can actually build it. So architects, funding falls a little higher on their priority list than it does contractors. Once you know the money's going to be there in terms of a project, if you're a contractor, because if it's going to be let, they're going to have money to pay for it. With the architects and the engineers, you're only going to get work if there's money there. So it's important to make sure that the funding is there for not only rehabilitation projects and new projects, but also for the maintenance of existing property that belongs to the state of Tennessee. With contractors, a lot of times, and we've seen here recently, there are plenty of statutes that apply across the board with employment, lien rights, protecting the right of payment. And it's important to have consistency among those statutes and regulations. And working across the state of Tennessee, whether you're in Memphis or up in Mountain City, on the other side of the state, you want to know that when you're traveling as an employer, and whether it be as a designer or a contractor, that the statutes that are going to apply are going to be, there's going to be some predictability about that. And so the consistency of regulations is of utmost importance. In terms of risk of non-payment, a lot of that was addressed last year, but it's always something that is ongoing. There's always a better way to do things. And so contractors in particular are on the lookout for ways to make sure that if they're doing work, they're going to get paid. One of the biggest fallacies in the construction industry is that banks are the lenders of primary lenders of a project. When in reality, that a lot of the financing for projects comes from designers and contractors. So they're doing the work in advance. They're sometimes not getting paid for at least 30 days, in some cases 90 to 120 days. So ensuring that if they're going to do the work, that there's going to be money flowing to them on down the timeline. And then in terms of employment statutes, again, this is something that we see applicable to the industry across the board. But in terms of contractors here, it seems to be where a lot of the irons are hot right now in terms of issues, whether it be E-Verify, drug testing when you're dealing with marijuana, and some other issues. Then again, with the general industry, some of the other considerations that we've seen play out this year and in years past are on limitations of liability, payment guarantees, lien rights, not only in terms of the ability to assert and obtain a lien, but also to enforce the lien, and then that determining what that lien's priority is, not only between contractors, but also with other interested project stakeholders like the bank and the owner. One of the big issues that happened this year just to the south of us in Alabama was the passage of an anti-indemnity statute. We already have a limited anti-indemnity statute here in Tennessee, and we'll talk a little bit about how those compare and where we see that going here in Tennessee. But that is another, risk management is a huge part of the business in construction. And so we'll talk about a few ways that is addressed currently and where it can go in the future. From a state perspective, as it applies to the construction industry, there was a push to get a constitutional amendment to preserve the right to work in the state of Tennessee. And in addition to that, there was also a big push to make sure that small business owners and minority business owners had sufficient opportunities for public contracting here in the state of Tennessee. So getting a little more specific, what are a couple of the successes for designers in Tennessee this year? The first is the defeat of I termed it license deregulation. There were two separate bills that dealt with licensing. If you're to practice architecture, engineering, and surveying, landscape architecture, and interior design here in the state of Tennessee, you have to have a license from the appropriate board. Same with contractors. It's a little more specific in terms of innovation and one of the acts for designers, but right now that has been defeated. It is not gone, but it's certainly been delayed, I will say, in terms of maintaining licensing requirements here in the state of Tennessee. And the second, in terms of funding, is providing tax credits. Tax credits were sought for certain historic projects here in the state of Tennessee, particularly in rural areas. But that was not passed as written, but it was addressed through a grant mechanism that we'll talk about. And so that, in addition to preserving funding for capital projects and maintenance of right at $1 billion, is a huge win for the construction industry as a whole, but particularly for designers on the front end, to make sure that, in the uncertainty of COVID, that there is going to be work, at least on the public side of things, for the foreseeable future. So in terms of license deregulation, the first bill we're going to talk about today is House Bill 1081. You will notice on other slides that you will always see a Senate bill number and a House bill number, as well as a Senate sponsor and a House sponsor. This is a bill, as it says, that sought to require a licensing authority to guarantee that a person who moves to Tennessee will be granted a license in their respective profession, provided they had a valid license and hold a valid license in the other state. So this is currently just a House bill, does not have a Senate sponsor. So in this legislative session, it did not get very far, but it's certain to be something that is going to be discussed next year. And is going to get a lot of comment, not only from architects, engineers, but also from contractors and really many other professions, because it is a fairly broad bill, the title suggests, universal license recognition. So the idea of license recognition in the abstract, there are plenty of opportunities for comity already with the licensing boards, where they say if you have a license in another state that has similar requirements to what we require in the state of Tennessee, we can agree that if you have that license, we'll grant you a license here as well. That is an agreement that is made at the state level between the two respective boards. It is not something that is done on an individual basis in terms of singling someone out. If somebody from California comes to Tennessee and says, hey, I have a legal license, or I have a contractor's license, or I have a license to practice architectural engineering, I should be able to practice in Tennessee. Unless there is a pre-existing comity agreement, they still have to take the appropriate examinations. They still have to show that they have the financial capacity to be able to justify whatever their limits would be, or that they have the requisite experience to be able to obtain that license. In the abstract, that seems like a good idea. Somebody moves here, there are a number of considerations that would weigh in favor of letting somebody have a license. One, it's good that the state's getting new residents. That means there's going to be a greater tax basis here. If they're bringing business in with them, obviously that's something that would benefit the state. But there are also a number of countervailing arguments there. One is that, in terms of people we want to protect, obviously the military comes to mind with a number of military bases here in the state of Tennessee, and military facilities. If somebody moves, and they have a spouse who was a contractor somewhere else, or a spouse who was an architect or engineer, that's something that a lot of people could agree, yes, in that scenario, that's somebody that we should allow to have a license in Tennessee, provided they meet all of the other requirements. And Tennessee law already addresses that with an expedited procedure to get those folks licensed as quickly as possible. But what you don't want to have happen is have a flood of people who would be qualified somewhere else under another state's laws that are different than Tennessee's. It's one of those where people talk about regressing to the mean a lot and coming to the average. This is a scenario where you go further than that and you really regress to the lowest possible standard, because depending on which state you're in, there are very relaxed requirements for what is required, not only for a contractor's license, but also to get a professional registration as an architect, engineer, surveyor, interior designer, or landscape architect. And what you don't want to have happen is somebody who would not be qualified under Tennessee law all of a sudden be able to do business in Tennessee just because they were able to meet whatever that lowest standard is. When we talk about negligence, it's always based on a reasonableness standard, not on what's the lowest possible standard you could get. And so in terms of the standard of care, it raises tremendous questions about, what now is the standard of care? Is it what a Tennessee architect, engineer, contractor would do, or is it whatever that person from whatever state they're from that, barely got a license, what they would do? There's some issues there. There's also a tremendous focus on competition. Somebody who's coming from a license that has a license from another state that does not have the same requirements as the state of Tennessee might not have the same qualifications. They might not have the same financial capacity. There's a consumer protection aspect that goes along with it. So there's plenty of considerations that go along with this. Whereas this bill, as you can see from the factors here, essentially says, as long as they have a license somewhere else, had it for at least a year, and as long as it's current, they should be able to get a license. One thing I note is that if you look at factor number 5, that the person has not been disciplined, or if so, that the matter has been addressed. There are numerous instances here in Tennessee where somebody has been cited for violating one of the licensing or registration statutes. And minor violations, are not going to prohibit somebody from obtaining a license, but there's some that would cause significant problems. What may be a huge issue here in Tennessee may not be an issue somewhere else. And so that is another factor that raises some questions about a person's responsibility and character, fitness, and ability to be appropriate license here in Tennessee. Again, right now, this bill is sitting pretty stagnant. But it's expected that next year there will be a Senate sponsor, and it could move forward depending on the support it gets. But it's definitely something to keep in mind. And if you have an interest with it, I suggest you speak with the relevant representative senator for your district or the district that you do business in. The next bill is similar but different in that it's titled the Innovation Fast Track Act. It deals with licensing, and what it sought to do is essentially create an innovation sandbox program where any license that falls under the Department of Commerce and Insurance, excuse me, if somebody had an innovative idea or an innovation or an invention that they wanted to test out and use as a pilot program, that they could essentially get a fast track to a license. In reality, what the bill did was make it so that the Department of Commerce and Insurance could grant a license to somebody under this program and essentially waive all of the other requirements of the license. They would still have to have a license, but they may not have to have the financial capacity to do it. They may not have to have the requisite experience or the track record that shows that, yes, this is somebody that we think is not only capable of doing business, but that we want to do business here in the state of Tennessee. That bill, as you can see under the status, is currently in the committees. It did not get out of the committees this year, but it's certainly something that's going to garner a lot of attention moving forward. The Innovation Fast Track Act, excuse me, the Innovation Fast Track Act is something that's not only present here in the state of Tennessee, but is also being pushed in other states across the country. They've had some success. For instance, in Kentucky, there is an Innovation Fast Track Act that dealt with a much more narrow scope, dealing only with the insurance industry. So if there was a particular type of insurance that they wanted to market that wasn't really addressed under current law, they were allowed to do so in that aspect. But again, very limited in scope, whereas the current version of this bill is very, very broad and applies to anything that falls within commerce and industry, commerce and insurance. Definitely something to be aware of. It's still relatively vague as to what would constitute an innovation, but in terms of the requirements for a contractor's license or any professional license on the design side, it's something to be aware of and keep track of because it has the potential to allow essentially unqualified and irresponsible businesses and entities to come into the state of Tennessee to test those acts. Now, the one point I will make on that is that this bill is very clear in that although it does away with the essential license requirements, not the requirement to have a license, but the requirements to obtain the license, all other statutes within the state of Tennessee are still applicable. So consumer protection is still in play. Building codes are still in play. Essentially, all it does is allow somebody to come in and have an expedited procedure to get a license when they may not otherwise be entitled to one. Another success for architects and engineers is in terms of funding. As we talked about, for several years, there has been a push to try and get tax credits for rehabilitation of certified historic structures. That was going to have a cap of $500,000. It's been on the table for a number of years now and had not been passed until this year. As part of the effort to get some relief for some of the rural communities, in a lot of the larger municipalities here in Tennessee, Knoxville, Nashville, Memphis, Chattanooga, there's plenty of development going on. And so there's not really that need to try and get owners to over the hump if they have a question about whether or not to do a project. In the rural communities, those same aspects in the development are not as great. And so there are incentives that we want to be able to provide to make sure that development occurs all across the state, not just in the large municipalities. As part of a compromise on that, the state of Tennessee decided that instead of doing tax credits, what they would do is initiate a grant program in lieu of those credits, which would be up to $5 million each year, each of the next 4 years, with a commitment to look at that again and see if that is a program that needs to continue on in the future, either in the same form or to go to a system where there would be tax credits that would be available for those types of projects. Again, it's a program that is focused primarily on rural communities as opposed to the municipalities, but is one of those that if a project is borderline, no go, based on funding, this provides an avenue for projects to be included within that. It is retroactive to a point in that if a project was commenced sometime in 2020 or afterwards, That project would be eligible for this, provided that it had a limited completion date. And you can't start a project and then have it go on for 4 years under this program. It's got to be reasonable under the circumstances, and I believe it's between 18 to 20 months for completion. And then in terms of capital projects generally, the state of Tennessee, as part of the budget, included roughly $1 billion that's going to go to capital projects, new projects, as well as maintenance of those existing facilities, which is great news not only for designers, but also for contractors. As we talk about contractors, again, a minute ago, I mentioned some of the primary considerations being employment laws, consistency within regulations and statutes, as well as making sure that the risk of non-payment lies with the party that is best able to manage it, oftentimes the owner. As we look at some of the bills that were here, another big consideration in terms of reliability and consistency among legislation is not only do you want state statutes to be complementary as opposed to having some sort of conflict internally, you also want to know that regardless of where you're at in the state of Tennessee, that you're going to be able to do business relatively the same. There may be some minor differences. There may be some minor code issues between two different municipalities, but largely you want things to be the same across the state of Tennessee. There's been in recent years, particularly here in Nashville, there has been an effort of municipalities to try and impose greater requirements than what would otherwise be required under the state statute. There's also some variance in between those about preserving work for people that live within a particular district or within the particular county or within the particular municipality. And one of those, a number of years ago, the state of Tennessee, a bill that they used to address that was in terms of requirements of various municipalities to say that if you're going to have work here, you need to employ people who live here. Said another way, it was there were a lot of cities that, if we have a project, your employees have to live within a certain geographic distance of wherever the project site is. There is a statutory prohibition against that. Tennessee says it doesn't matter where a project is. If you want to go there and do the work, you can take whoever you want to be a part of that. That is something that causes a lot of strife between union and non-union contractors, and that's where a large interest of this bill is placed. But Senator Akbari, who's out in West Tennessee, and Representative Mitchell filed a bill, Senate Bill 1436, House Bill 1561, that sought to delete that statutory prohibition and allow municipalities to decide who they were going to allow to work on that particular project. The idea being, if I'm paying for it, I should get to say who is going to benefit from this project, not only from the end result, but also who is going to be able to receive the funds for that money in terms of the people who are performing labor and providing materials on that project. That bill never really got off the ground, but it's stuck in committee right now, but it is one based on the fact that we have a 2-year legislative cycle that's going to be kicked into next year and is likely to get some support, but is not likely, in my opinion, to actually be passed with the current legislature makeup and the governor. You also have, as we talked about, some proposed ordinances by various municipalities that try and take additional action against contractors and designers who want to do work in that particular jurisdiction. Today, we're going to focus on a couple of ordinances here in Nashville-Davidson County, but it's representative of what you see in Memphis, Chattanooga, Knoxville at various times. So here in Nashville, earlier this year, Councilwoman Joy Stiles filed a proposed ordinance that would require disclosure of certain employee information, including their name, their wage, hours worked, hire date, classification, employment status, age, address, and phone number, as well as if they had any TOSHA or OSHA training. Notably, it says OSHA 10 here. There's a requirement of whether it be OSHA 10, OSHA 100, what employees would be trained and when they received that training. This ordinance arose, some of you may be familiar with this, last fall on a project in Nashville. There was a teenage worker who fell off a scaffolding setup and ended up passing away. OSHA and TOSHA got involved, and it was one that caused a lot of concern here locally in that, what contractors are doing, are they doing it, are they taking enough action to make sure that their employees are safe? It's not only that project, there were a number of different projects that headlines this year over employee safety and various injuries that occurred on a project or near misses. And so under this proposed ordinance, it was going to require a lot of this information, essentially to provide Metro information on who was working where, were they properly trained? Did they have enough training to be doing the work they were actually doing? There's a number of concerns that arise with this. One, you have from a state level, the state likes to make the rules. It doesn't like Metro or any other municipality going above and beyond because the state considers itself the expert, particularly when it comes to employee safety, since they're responsible for the TOSHA program. From the employee aspect, you have a lot of employees that are, they get hired and they're hired with the expectation that they're going to be doing their work. They don't get hired with the expectation that their business is going to be known to everybody in the world. The reason that becomes an issue is, as many of you may be aware, there are Freedom of Information Acts and Public Record Acts here in Tennessee that allow anybody to obtain copies of public records. And so that's generally the rule unless there is an exemption. There have been a number of cases here recently that have made clear that employee information is not something that has an exemption under any of the Public Records Acts. So all of this information you see on the slide would be available to anybody that walked in to Metro's office or any other municipality's office that had a similar requirement. Obviously that one faced a fair amount of opposition, but following there's a number of companion bills to this. Rarely is it that one person has an idea on their own. So a second proposed amendment was filed, not only that was signed on by Council Member Stiles, but a number of the other council members. This one going back to the project that I mentioned a minute ago with the teenager that passed away, sought to provide the codes office the authority and the ability to require the imposition of a stop work order on any project that was subject to an OSHA or TOSHA citation. It also prohibited the issuance of a certificate of use and occupancy if the issue that was the basis for the citation had not been abated, or if the OSHA and TOSHA citation had not been fully resolved. Obviously, that has huge impacts to a project. Not only from a scheduling aspect, if you have a stop work order on a project, you're obviously going to be delayed. That's necessarily going to increase the cost of construction. If liquidated damages are a part of the project, that's going to be another factor that goes in there. But it's essentially, time is money. Every day the project's not completed, it's money that somebody is losing. Whether it be the contractor in terms of additional overhead, designers and having to come up with measures to ensure that particular aspects of the project. If you've got metal hanging out, how are you going to support that? Interim actions that have to be taken, and the same if a project can't be completed. Obviously, the owner throughout this whole part, the whole goal is that some project is going to make money somehow, either through use or through leasing if it's a commercial aspect. It has huge issues there in terms of the financial aspects and delay aspects, but also from a legal standpoint, there's a lot of due process issues that arise with this. There is not a requirement that there actually be proven to be a violation. We represent many architects, engineers, and contractors before OSHA, and oftentimes TOSHA has whatever standard they say is applicable. There's always a defense to. It could be employee misconduct. It could be something where in that instance where there's no doubt there was a violation, but there's no liability on the part of the employer. There's other scenarios where TOSHA may believe a certain standard applies, but an employer is able to show that standard's not applicable on a particular project. You also have, if there's not a specific standard, TOSHA can always go under the general duty clause, which is always subject to interpretation. And it's one where most employers in that instance, it's not a cited standard. It's not something you would have had reasonable notice of. There are certainly other defenses that you can raise throughout that whole process. But at the end of the day, the biggest issue is your work is stopped for something that you may or may not ever be liable for. Then you get into the fact that particularly with TOSHA and OSHA, it's an administrative proceeding. And so by the time that gets taken care of, it could be at least 6 months to a year down the road before it's ever lifted. And so you're going to have a project sitting idle for a tremendous amount of time. That is especially true in COVID because TOSHA is essentially staying all of their enforcement proceedings. So, that 6 month to a year timeline, all of a sudden go ahead and add another year onto it at least, added to the fact that most TOSHA citations are not, TOSHA has up to 6 months from the date of the incident for any TOSHA citation to actually issue a citation. So you have a period of upwards of years that could be added on to delay a project. And that's just something that is unreasonable in the minds of architects, engineers, and contractors, and from lawyers creates a huge due process concern. So not only would it cause practical aspects to the project, it's something that may or may not even be enforceable, but it's going to take a lot of action to get over that. So finally, you had a proposed ordinance that was led by Councilmember Sepulveda, along with a host of the other council members, that was really more of a wrap-up ordinance of a lot of different ordinances, including the two we just talked about. In the first part of this ordinance sought to reorganize the Procurement Standards Board, which is a board, an entity within Metro government that was responsible for promulgating procurement regulations, deciding who was a responsible bidder, or for architects and engineers, who was a responsible offeror in terms of getting work. It says, okay, we're willing to do business with you, you're responsible, we're not willing to do business with you over here. It expanded the membership from 5 to 7. Notable new members were one representative of labor and another member of an apprenticeship program. That in and of itself caused a lot of heartburn for contractors. The biggest issue being the redefining of the term responsible bidder or offeror. Historically, a responsible bidder or offeror, in addition to having the requisite experience and wherewithal to be able to do a project, there was also a prohibition against anybody that had a finding that they had violated a number of the employment regulations. Those included the Fair Labor Standards Act, Title VII of the Civil Rights Act, the Family Medical Leave Act, the Age Discrimination and Employment Act, the ADA, the Rehabilitation Act, and the Education Amendments Act. You may not be familiar with all of those, but those statutes generally deal with employment and discrimination. And I think everybody can agree those are things that we don't want to be part of the employment. If you're not somebody who's doing things right and doing things the right way, making sure that anybody who is capable of being employed is not taking any discriminatory actions, I think we can all agree with that. Where they started to have problems was adding to that list with the national violations of the National Labor Relations Act, the Tennessee Wage Regulation Act, and the Tennessee Occupational Safety and Health Act. Going back to those two prior ordinances, there are certainly due process issues as well as many practical issues with having a finding by TOSHA that there was a violation. The issuance of a citation in and of itself is technically a finding. It's not a final finding, which is a huge difference. The same holds true with the National Labor Relations Act, which generally deals with charges that there has been a violation of an employee's right under either to be a part of or not be a part of a labor organization, or taking action against an employee because of that decision. Again, that's an administratively determined action, initially at least, through an administrative procedure, much like TOSHA. It is one that takes many years, oftentimes, to get through the process, and it's one where it makes absolutely no sense. Without a final finding, there's no reason to take action against a designer or a contractor for any of those three acts. The big caveat to that is, or the important aspect of that is, if you are found to not be responsible or a responsible bidder or a responsible offeror, obviously you can't do business with Metro. So again, the due process issues here are very, very great and raised a lot of concern with contractors and designers. But you add to that, this is a very broad ordinance. It also imposed a number of additional requirements on designers and contractors. One being that it required written agreements at all levels of the contracting tier in the contracting chain. So regardless of how far down the chain you are, you had to have a written agreement that had to be collected by the general contractor or the designer, whoever had the contract with Metro, and then passed along to Metro. That again becomes a public record. There's a number of competitive concerns with that. from pricing, who you're using, who your consultants are, who your subcontractors are, things that may or may not necessarily be public knowledge all of the sudden are. There's also a requirement that whoever held the contract with Metro is responsible for everybody's compliance with all of the requirements that are within this ordinance. So you have, it's not uncommon for, smaller subcontractors, one-man shop consultants to go off of either a letter agreement that may never be signed, may still be spit in a handshake, maybe just go do the work and then you send me an invoice. All of those scenarios which are customary within the construction industry and totally acceptable, all of a sudden raise liability for not only the architect and the engineer, but also for the contractor, as well as the subcontractors and consultants they're using. It also required, similar to that first ordinance we were looking at, required the disclosure of information for a number of different issues based on, or a number of different aspects of the employment relationship, as well as the training requirements of the employees, health benefits and workers' compensation aspects that are proprietary to individual designers and contractors, and really just puts all of that information out in the public domain and raises a lot of privacy concerns. A couple of COVID-specific requirements here in terms of requiring hand washing stations on each floor. That's not really, a big deal in terms of being something that people would be offended by, nor are having multiple toilets on each work site. That was more of an accommodation for a lot of workers that I think everybody can get on board with. But what was causing some additional concern was the requirement that any temporary employees, if they worked 30 consecutive days, had to become a full-time employee of someone, and in this case, namely, whoever had the contract with Metro. And you might be thinking to yourself, well, how is Metro able to take all of this action? I thought that employment and other regulations like this were a matter of state or federal law, and they are. Generally, state regulations can be more strict than the federal law. Municipalities can have rules that are more strict than the state law. But you have a lot of territorialism going on, where if we came up with the rules, those are our rules, and we don't think you should go much beyond that. There's also a lot of struggle between the individual municipalities in the state of Tennessee. The state of Tennessee, being the entity that pays for and manages TOSHA and some of these other administrative agencies, is the subject matter expert. And so the state of Tennessee took action with Senate Bill 1150 and House Bill 1112, and essentially negated much of what Metro was trying to do, and said, we are the subject matter experts here. If you are a municipality, you can't require contractors and designers to provide the information on their employees. You can't require them to adhere to stricter safety and health standards than what we require either under TOSHA or what federal OSHA requires. And another aspect of this that we haven't talked about yet is you can't require those entities that you do business with to provide access to their documents and their information to people who are not part of the project. One aspect of the Sepulveda ordinance was that there was this broad ability of Metro to allow somebody to go to your office and review all of your records for compliance with the ordinance. There was no requirement that it be a Metro employee. There was no requirement that they'd be a CPA or other certified auditor. It literally it was wide open to be whoever they wanted. And so obviously that raises a number of concerns, not only with privacy, but what somebody would be doing with that information, as well as how you maintain it, how you produce it. But the end result is the state of Tennessee put a kibosh on that and said, no, thank you very much. And that bill was signed by the governor on April 22nd, 2001. So now it's very clear that there are limits to what municipalities can do, and that the state is prepared to take action to make sure that the requirements of the state are what are going to apply across the board in Tennessee for contractors and designers, and provide a little more predictability in terms of the rules that are applicable to the work that's being performed. Another bill that is before the legislature currently, there was no action taken on it this year, but is certainly going to be a hot button issue next year, is a bill that was filed that seeks to prohibit an owner, investor, developer, contractor, really anybody upstream of you, to withhold your payment until you've executed a waiver other than a standard lien waiver. I've kind of done a broad brush with that, and in the abstract, it doesn't sound bad. in Tennessee, we're a conditional lien waiver state anyway. You could sign an unconditional lien waiver as you're going on in a project, but at the end of the day, Tennessee construes all of those lien waivers as being conditional until you have received payment. And so that is from a common law, court law, case law aspect of things, not a statutory aspect. But what this bill sought to do was essentially say, if I'm signing a lien waiver, the only rights I'm waiving are my lien rights for this specific portion. The way it's drafted is a little bit broader than that, as you can see from the language here. And you may be saying, well, what's the issue with that? Well, the way it's drafted, there's a couple of questions. One is, what would the effect on subordination agreements be? Technically under a subordination agreement, it's something that lenders require a lot of times from not only contractors, but from designers as well, to say your lien rights are going to be subordinate or junior to the deed of trust that's on the project. So that if the owner defaults and the lender ends up foreclosing on the project, the lien rights are going to be extinguished. Where that comes into play is a lot of times, particularly with designers, they're doing a lot of their work on the front end of a project, maybe even before an owner has obtained title to the property. With contractors, there's a lot of preliminary work they're doing out on the site that may be done before the financing is fully into place, and before the deed of trust has been recorded. And so the goal there is, the lender wants a subordination agreement in place, which waives those lien rights, or at least the priority of those lien rights, before potentially anybody's gotten paid at all. And there is never any money that is paid for that, or if there is, in theory, it's just written into the agreement itself, saying a portion of the contract price is being paid as consideration for the subordination agreement. That is one aspect. It's not really addressed there, and technically a subordination agreement would violate that statute. So the enforceability of that, certainly to raise questions by the lenders. The next is just the general validity of settlement agreements. As part of any settlement agreement, you are waiving your rights to be able to recover some portion of an amount that would be due to you, or not only in terms of lien rights, but in terms of the money. Obviously, it would be over and above the money that is being due and paid. So, what effect does that proposed legislation have on settlement agreements? As I mentioned, that met some resistance early on and has been rolled into 22 or the 22 session, and is certainly to garner a lot of interest, not only amongst contractors, but also amongst designers, lenders, owners. But there's likely to be some action taken in terms of that legislation. The next is more of an employment bill as opposed to something that's dealing specifically with construction, and that's the drug testing for marijuana. Senator Campbell and Representative Harris introduced a bill that would prevent employers from discriminating or taking employment action against an employee based on drug tests that indicated the use of marijuana. A lot of times that's going to be the initial drug test on hiring. If it comes back with marijuana right now, that's something, employers can make decisions on. What it sought to do was, following the recent trend of the decriminalization of marijuana, to say, well, just because somebody uses marijuana doesn't mean that they're going to use it in the future. It also doesn't mean that it would affect their job performance. There were some exceptions to that, though. One is that if there was a drug test that indicated there was an employee that was using marijuana at work, that would not be something that you couldn't take action for. And then there were exceptions if a position was in school or within the medical profession. There's some other exceptions that go along with that. But obviously that raises some employment concerns throughout the construction industry for folks that don't want employees. If you've got a drug-free workplace, you want to preserve that, obviously that would be difficult under this bill that restricted you from being able to take employment action against somebody that was using marijuana. There was no action taken on that this year. And I say no action, I mean it was not passed. That bill is still before various committees and subcommittees within the Senate and the House, and has been rolled into 2022. There are a number, this is just one bill, there are a number of bills that are dealing with marijuana use that are pending before the legislature. And so I think it's safe to assume that is going to be a hot topic next year, particularly when you consider that Tennessee is considering some other action in terms of the legalization to some extent of marijuana and cannabis. The next is the use of E-Verify. This is another one of those bills that seems to come up every year in some shape or form. And what the goal is depending on who the Senate or House sponsor is to get all entities within the state of Tennessee, not just contractors and designers, but everybody to use E-Verify to verify employment of potential employees. As the law currently stands, obviously an employer can use E-Verify for new employees to make sure that they're authorized to work in the United States and in the state of Tennessee. But there are other modes of other means to identify whether the employee is authorized to work, other forms of identification that are acceptable. And if those forms are, if an employee takes those forms of identification and an employee is later found to not be authorized, there is some immunity in instances for an employer from being penalized for that. What this bill sought to do was essentially to switch that to make the presumption apply only if the employer used E-Verify, and actually remove the exemption and the immunity for an employee that relied on other acceptable forms of verification under federal law. So as it stands right now, that remains pending in the Senate. It failed in the House and is likely dead, but there are other similar bills out there. And that is certainly something that in the future is going to arise, if not next year, in the years to come. Some of the state initiatives that we saw this year were a state constitutional amendment, a joint resolution calling for a constitutional amendment that proposed adding a provision in the Tennessee Constitution that established a right to work regardless of an employee's affiliation with a labor organization. That resolution passed both the House and the Senate after 3 readings and will be added to the 22 general election ballot next year to determine whether that should be included within the Tennessee Constitution. Now, one thing I want to clarify is, what is the right to work? You hear right to work and employment at will, and a lot of times people use those interchangeably, but they're very different and distinct concepts. The right to work guarantees that no person can be compelled to join or not join a labor organization, or to pay dues to that organization as a condition of their employment. It essentially says, if I want to join a union, I can. If I don't want to join a union, I don't have to. Under the federal Taft-Hartley Act, it affirms that individual states can determine what the right to work should be in their state, whether there should be right to work laws, whether there should not be, and how those are going to affect employees. Yeah, the question is that something that needs to be in a constitutional amendment? The response is, at least from the legislature, it's the fact that we have the right to do that right now is great. With a Republican-controlled Congress, they feel or a Republican-controlled legislature, they feel very strongly that the right to work in Tennessee should remain and is unlikely to go away. But there are no guarantees in life, and legislatures can change hands politically from one session to the next. And so what their goal is, by putting it in the Tennessee Constitution, is to make it more difficult on down the road to ever change the right to work here in Tennessee. You contrast that with employment at will, which generally governs employment relationships across the state of Tennessee, and so where an employee does not have a written contract for employment, it says that either party can terminate the employment relationship at will for any cause. So employment at will is just for at will employment. Either party can terminate. There's no requirement that you give notice or a reason or have a justification. Whereas the right to work is, I don't have to join a union, or you can't keep me from joining a union, depending on the perspective. Another kind of miscellaneous bill dealing specifically with contracting was that Senate Bill 577, sponsored by Senator Crow, revised the definition of contractor to exclude essentially on-site advertising displays, whether it be a sign, some sort of blow up, something that would require typically a contractor to construct, but where it is, the person doing it is either the owner, or they're not receiving compensation for installing the advertisement or the digital display device. They do not have to be licensed in the state of Tennessee. Generally, historically, that's something that was governed by a specialty classification, and still required that the individual have the requisite financial wherewithal as well as experience to do that. It's kind of a niche business, and under this bill, that is taken out of the scope of the Board of Licensing Contractors. As I talked about earlier, kind of outside of Tennessee, one of the big aspects, or one of the big issues, was in Alabama dealing with anti-indemnity statutes. under general negligence principles, everybody has insurance, whether you're a contractor, architect, engineer. The goal of insurance is to cover you for damages that you cause. So in Tennessee, we call that comparative fault. I'm liable for what I do, compared to John Smith over here, who's going to be liable for what he has actually caused. So if you have multiple actors, if you have four people that all cause the same damage, each of them equally responsible, they're each liable for 25% of the damages, no more, no less. Indemnity provisions in contract tend to try and switch that to make you responsible for more than you would otherwise be. Many states, I think there's only 6 now, that don't have some sort of anti-indemnity statute. Alabama used to be one of them up until this year, when it enacted a specific anti-indemnity statute applicable to designers. In that statute, it says essentially a designer cannot be required in any contract to indemnify somebody for anyone else's negligence other than their own. So I'm not required to indemnify as an architect engineer doing business in Alabama. I'm not required to indemnify the owner or any other party for damages unless and only to the extent that they were caused by my actions, errors, or omissions. The reason this makes sense is the way insurance works, particularly professional liability insurance. It is written on a negligence basis and only covers the acts of the designer. So if there's $1 million in damage, but only half of that is determined to be caused by the designer is only responsible for $500,000 worth and can't be required in a contract to pay more than that. The goal being, if you're going to have these exhaustive insurance requirements as part of a construction contract, you need to make sure, one, that the insurance is valid, and two, that it's only going to cover what it's intended to cover. The similar issue to that is the duty of defense. Professional liability policies are totally different than a commercial general liability policy. Professional liability policies do not provide a duty to defend because they're not going to pay out money. And when I say they, the insurers, they're not going to pay out money to defend a claim that is not covered by the policy. So if it's only covering the acts and omissions of the designer, they're not going to cover some other cause. And so what that statute down in Alabama does is makes clear that the duty to defend is not applicable except to the extent of the design professional's liability. And essentially says, unless it's covered by the insurance policy, you can't require them to pay it out or to become responsible for it. One thing I want to make clear on that is the fact that there is this anti-indemnity statute does not change the fact that if there is a breach of contract and a justification for the payment of damages elsewhere in the agreement, it does not make that null and void. That obligation would still be valid in the state of Alabama. The only thing this changes is in terms of the indemnity agreement itself. The other is that a design professional cannot be required to add another person as an additional insured on the professional liability policy. From a practical perspective, that's not something you can do anyway. And so it's codifying what everybody else knows, is that you can't have somebody else on an insurance policy unless they're a named insured and unless the insurer is actually getting premiums for that person. The whole point being, an insurance company is not going to insure somebody that they haven't checked out and made sure that they want to insure. It adds liability for the insurance company if that were the case, which it's not and can't be. But it's just clarifying that what is going to apply is what is going to be covered under the insurance policy. The final point of the Alabama statute, and is somewhat unique, is that the policy or the statute makes clear that there's going to be a statutory standard of care. You see standards of care throughout construction contracts, particularly in the form agreements with the AIA documents, the EJCDC documents, and then the consensus documents that have some variation of a standard of care that says, if you are a design professional or a contractor, you are going to perform with that degree of skill and care that everybody else would. You're going to do the same things that somebody else would do under the same and similar circumstances. Alabama's standard of care is a little bit different than what you would see in any of those form agreements, by saying that the design professional will perform its services with the professional skill and care ordinarily provided by a competent design professional practicing under the same or similar circumstances and professional licenses as expeditiously and as as expeditiously as is prudent considering the ordinary professional skill and care of a competent design professional. A little wordy, but in general says you're going to do the same thing as everybody else would do under the same or similar circumstances. The interesting part about this is there is no longer any contractual standard of care that can vary from that. That's it. So you get back to a true negligence standard in terms of the design professional's actions. And the goal of all of that is to make sure that you're going to preserve the insurance coverage that's required under the professional liability policy. Now, it's using design professional. Who does that apply to? It applies to anybody who's licensed to practice architecture, landscape architecture, surveying, engineering, interior design, or geology within the state of Alabama. So any of the typical design trades that you would see, regardless of subclassification. Now, compare that to Tennessee's anti-indemnity statute, which in essence says you can't have an agreement to indemnify somebody against liability that results from the sole negligence of the party who's going to be indemnified. Those are void and unenforceable. Under Alabama law, it's now saying the design professional is responsible for themselves and themselves alone. In Tennessee, you still have a scenario where if I am 1% liable and somebody else is 99% liable, I can be responsible for the whole thing. There have been some actions in years past to try and change that. And you know, it's something that could be on the table in years to come, but just something to be aware of. In reality, it's something that makes good sense following the trend of Alabama and several other states, is to make people responsible only for what they're responsible for, as opposed to taking on risk and liability for somebody that you have no control over. Moving on a similar note, one thing I want to hit from the last legislative session is that limitations of liability are clearly not against the public policy or the public interest of the state of Tennessee. For limitations of liability, this essentially says, you know, I may be liable for something, but we're going to put a hard cap on what my liability would be, regardless of what the damages are. This applies equally to contractors, designers, anybody involved in the supervision, observation, and construction. So subcontractors, really most everybody on a project. It does not include surveyors, but pretty much everybody else on a construction project can have a limitation of liability in the state of Tennessee. Now, the courts use a series of factors when they're looking at limitations of liability in Tennessee to decide whether or not they're valid. One, and the most important, is whether it violates the public policy of Tennessee. When you get into that, it's whether parties have equal bargaining power, whether the amount is reasonable under the circumstances, you know, what the limitation of liability is compared to what the damages are. Those factors are still going to be in play, but what the statute did was make clear that, you know, from that initial threshold question of is it going to violate the public policy of the state of Tennessee, Tennessee legislature said no. So there is that avenue, even with an anti-indemnity statute that is a little more broad than others and allows for indemnification of greater than what a general negligence standard is. You still have the ability to have a limitation of liability. Well, looking at the time, we're at about an hour. So if you have any questions, particularly in regard to what we've talked about today or any of the construction statutes that were amended from last year, I would encourage you to reach out to me. My contact information is listed here below. Feel free to shoot me an email, give me a phone call at any time. And if you're located near to one of our other offices, feel free to give them a call as well in Knoxville or Memphis. And if you have any questions about who to contact, feel free to contact me and I'll put you in touch with the person who's best able to help you. I appreciate everybody joining on today. Like I say, if you have any questions, give us a call and we hope to see you at our next session. Have a great day.